Question 1. The British Parliament passed its very first act to control the East India Company in 1773. But here's what most students get wrong. What was the primary reason Parliament intervened at this point? A. The company had lost the Battle of Plassey. B. The company was on the verge of financial collapse and had asked Parliament for a loan. C. Indians had started revolting against company rule. D. The French were threatening British trade interests in India. The answer is B. This is a trap that catches almost every first-time student. Most people assume Parliament stepped in out of some noble desire for governance reform. No. The East India Company had run itself into serious financial trouble and came begging to the British Parliament for a loan of £1.4 million. Parliament said, "Fine, but we are going to start watching what you do." That watchfulness became the Regulating Act of 1773. Remember this. The first act of British parliamentary control over India was born from financial desperation, not political wisdom. Now that you know why it happened, let us see what it actually did. Question 2. Which of the following was introduced in India for the first time by the Regulating Act of 1773? A. A bicameral legislature. B. The office of Governor General. C. Separation of executive and legislative functions. D. A written constitution for the company. The answer is B. The Regulating Act 1773 created the post of Governor General of Bengal, and the first person to hold this office was Warren Hastings. This is your anchor fact. Before this, there were just governors of different presidencies, Bombay, Madras, Calcutta, all working independently with no one above them. The Regulating Act subordinated the governors of Bombay and Madras to this new Governor General of Bengal. That is your first centralization attempt in Indian constitutional history, and the Supreme Court at Calcutta, also established under this act in 1774, was India's first Supreme Court. 4 judges, 1 Chief Justice, and 3 Puin judges. Sir Elijah Impey was the first Chief Justice. These are frequently tested facts. Question 3. Statement 1. The Regulating Act 1773 prohibited servants of the East India Company from engaging in private trade and accepting bribes from natives. Statement 2. The Regulating Act 1773 made the Governor General of Bengal the supreme authority over all of India. Which of the following is correct? A. Both statements are correct. B. Statement 1 is correct, Statement 2 is incorrect. C. Statement 1 is incorrect, Statement 2 is correct. D. Both statements are incorrect. The answer is B. Statement 1 is absolutely correct. The Act did prohibit private trade and bribery by company servants. That was one of its explicit provisions. But Statement 2 contains a very tempting trap. The Governor General was made supreme over only the presidencies of Bombay and Madras, not over all of India. India as a unified administrative concept did not exist yet. The title Governor General of all India came much later, with the Charter Act of 1833. Keep these two apart, or you will lose marks on this distinction consistently. Question 4. Pitt's India Act of 1784 is sometimes called the foundation of the dual government system. What were the 2 pillars of this dual government? A. Court of Directors and Supreme Court. B. Board of Control and Court of Directors. C. Secretary of State and Board of Control. D. Governor General and Board of Directors. The answer is B. This one seems easy, but the options are designed to confuse you. Pitt's India Act 1784 created a Board of Control consisting of 6 members, 2 of whom were cabinet ministers, to supervise the political, military, and revenue affairs of the company. The Court of Directors continued to handle commercial matters, so you had political control with the Crown's Board of Control and commercial management with the company's Court of Directors. That is the dual government, 2 parallel structures managing India. Here is what makes this act historically significant beyond the structure. Pitt's India Act for the first time used the phrase British possessions in India. India was no longer just a trading territory. It was now officially recognized as a British possession. That phrase alone is a high-yield exam point. Question 5. Assertion A. The Charter Act of 1833 transformed the Governor-General of Bengal into the Governor-General of India. Reason R. This change was made to bring all three presidencies, Bengal, Bombay, and Madras, under a single unified administration. A. Both A and R are correct, and R is the correct explanation of A. B. Both A and R are correct, but R is not the correct explanation of A. C. A is correct, but R is incorrect. D. A is incorrect, but R is correct. The answer is A. Both the assertion and the reason are correct, and the reason perfectly explains the assertion. Before 1833, you had three relatively autonomous presidencies. The Charter Act of 1833 centralized the entire administration under one head, the Governor-General of India. Lord William Bentinck became the first Governor-General of India under this new arrangement. The Act also took away the legislative powers of Bombay and Madras presidencies. All laws were now to be made only at the central level. This is your first major centralization of legislative power in India. And one more thing the 1833 Act did that every exam loves to ask about. It abolished slavery in India. Also, it recommended an open competition system for civil services, though this recommendation was not immediately implemented. That had to wait until 1853. Question 6. Which Charter Act for the first time recommended the introduction of open competition for appointment to civil services in India? A. Charter Act 1813. B. Charter Act 1833. C. Charter Act 1853. D. Government of India Act 1858. The answer is C. This is a very commonly missed fact. The Charter Act of 1853, the last of the Charter Acts, recommended open competition for civil services. It said appointments should be based on merit through competitive examination rather than patronage. But notice, it only recommended this. The actual open competition system was implemented after the Macaulay Committee report following the Act. Some students confuse the 1833 Act here because it talked about merit appointments too, but 1853 is the one that formally recommended open competition through examination. Know this distinction cold. The 1853 Act also did something that gets tested heavily. It, for the first time, separated the legislative and executive functions of the Governor-General's Council. 6 additional members were added specifically for legislative business, making it function like a mini parliament. This is the seed from which India's parliamentary tradition grew. Question 7. Here's a problem-based question. The year is 1857. The Indian Mutiny has just been suppressed. The British Crown is furious with the East India Company for its mismanagement. Parliament passes a new act. Under this new act, which of the following correctly describes what happened? A. The company was abolished and all its powers were transferred to the Crown. B. The company was retained as a commercial body but lost all political powers. C. The company was merged with the Board of Control. D. The company was allowed to continue governing India under Crown supervision. The answer is A. The Government of India Act 1858 ended East India Company rule permanently. The Crown took direct control. This is what is meant by the Queen's Proclamation of 1858. Queen Victoria announced that she was taking India under her personal sovereignty. The Governor-General now wore 2 hats. He was called the Viceroy when acting as the Crown's personal representative, and still called the Governor-General when acting as the head of the Indian government. Lord Canning was the last Governor-General and the first Viceroy. The Board of Control created by Pitt's India Act was abolished. The Court of Directors was abolished. In their place came a new office, the Secretary of State for India, a cabinet-level position in the British Parliament. He was assisted by a Council of India with 15 members. This is your complete picture of 1858. Question 8. Which of the following is not correctly matched? A. Regulating Act 1773, First Governor-General of Bengal, Warren Hastings. B. Government of India Act 1858, First Viceroy of India, Lord Canning. C. Charter Act 1833, First Governor-General of India, Lord William Bentinck. D. Pitt's India Act 1784, First Secretary of State for India, Lord Morley. The answer is D. Did you spot it? The Secretary of State for India was created not by Pitt's India Act 1784, but by the Government of India Act 1858. Pitt's 1784 Act created the Board of Control. Lord Morley was indeed a Secretary of State for India, but he held that office during the Morley-Minto reforms of 1909, which is an entirely different act. Options A, B, and C are all correctly matched. This question tests whether you can cross-link names with correct acts, a classic trap in negative MCQs. Question 9. The Indian Councils Act of 1909 is associated with a landmark that no exam has ever let go of. What did this act introduce for the first time in India's constitutional history? A. Bicameralism at the central level. B. Provincial autonomy. C. Separate electorates for Muslims. D. Direct elections for legislative council members. The answer is C. This is your single most important fact from the 1909 Act. The Morley-Minto reforms introduced the system of separate electorates for Muslims, meaning Muslim voters would vote separately for Muslim representatives. This was the first formal injection of communal politics into India's constitutional framework, and it cast a long shadow all the way to partition in 1947. Lord Minto was the Viceroy. Lord Morley was the Secretary of State. Remember both names. The Act also introduced the principle of association of Indians with the executive councils. Satyendra Prasad Sinha became the first Indian to join the Viceroy's Executive Council as a law member. That is another high-yield fact. The Act also enlarged the legislative councils at both central and provincial levels, but it did not introduce bicameralism at the center. That came with the Government of India Act 1919. Track these firsts carefully. Question 10. Statement 1. The Government of India Act 1919 introduced Dyarchy in the provinces. Statement 2. Under Dyarchy, provincial subjects were divided into reserved and transferred subjects. Statement 3. Reserved subjects were administered by the governor with the help of ministers responsible to the legislature. Which of the following is correct? A. All three statements are correct. B. Statements 1 and 2 are correct. Statement 3 is incorrect. C. Only statement 1 is correct. D. Statements 2 and 3 are correct. Statement 1 is incorrect. The answer is B. This is a precision test. Statements 1 and 2 are perfectly correct. Dyarchy was introduced at the provincial level, not at the center, by the Government of India Act 1919, also called the Montagu-Chelmsford Reforms. The word dyarchy comes from the Greek, di meaning two, archy meaning rule. Provincial subjects were split into reserved subjects like finance, police, and justice, controlled by the governor with his executive councillors who were not responsible to the legislature, and transferred subjects like education, public health, and agriculture, handled by ministers who were responsible to the legislature. That is exactly why Statement 3 is wrong. It says reserved subjects were administered with ministers responsible to the legislature. That is the description of transferred subjects. Reserved subjects had no such accountability. The ministers responsible to the legislature handled transferred subjects. Flip these and you lose the mark. The 1919 Act also introduced bicameralism at the center, creating the Council of State as the upper house and the Legislative Assembly as the lower house. Montagu was Secretary of State, Chelmsford was Viceroy. Question 11. Match the following correctly. Column A. 1. Bicameralism introduced at the center. 2. Dyarchy introduced in provinces. 3. Provincial autonomy granted. 4. Federal court established. Column B. P. Government of India Act 1919. Q. Government of India Act 1935. R. Government of India Act 1919. S. Government of India Act 1935. The answer is B. Both bicameralism at the center and diarchy in provinces were introduced by the Government of India Act 1919. Both provincial autonomy and the federal court were introduced by the Government of India Act 1935. This question tests whether you are grouping the contributions of each act correctly in your mental map. The 1935 Act abolished diarchy from the provinces and granted them genuine autonomy, a major step forward. The federal court established under the 1935 Act began functioning in 1937 and was the direct predecessor to the Supreme Court of India, established after independence. Question 12. The Government of India Act 1935 is the most detailed constitutional document in pre-independence Indian history. Which of the following features of the Indian Constitution has been primarily borrowed from this Act? A. Fundamental rights and directive principles. B. Federal structure with a strong centre, emergency provisions, and governor's role. C. Parliamentary form of government and cabinet responsibility. D. Preamble and citizenship provisions. The answer is B. This question is asked in virtually every exam that tests constitutional history. The 1935 Act is the primary source of the Indian Constitution's federal structure, the division of powers between centre and states, the three legislative lists, emergency provisions, the role and powers of the governor, the Public Service Commission, the federal court structure. The Constitution borrowed so heavily from the 1935 Act that Dr. Ambedkar was actually criticised for it during the Constituent Assembly debates, and he defended the borrowing by saying that good provisions should not be rejected simply because they appeared in an act made by colonizers. Parliamentary government and cabinet responsibility come from the British model. Fundamental rights come from the American Constitution. Directive principles come from the Irish Constitution. Keep these source attributions organized. Question 13. Under the Government of India Act 1935, an All India Federation was proposed. This federation never came into existence. Why? A. The Indian National Congress refused to join the federation. B. The required number of Indian princes did not accede to join the federation. C. The British Parliament repealed this provision before it could be implemented. D. World War II broke out before the Federation could be notified. The answer is B. The federal part of the 1935 Act required the Indian princes, the rulers of the native states, to join the Federation by signing an instrument of accession. For the Federation to become operational, princes representing at least half the total number of states needed to sign. That threshold was never met because a sufficient number of princes refused. So the federal provisions of the 1935 Act were never operationalized. What did come into force were the provincial provisions, specifically provincial autonomy, which began in 1937. The Dyarchy at the centre, which was also proposed in the 1935 Act, also never came into operation for the same reason. Two significant provisions of the 1935 Act never saw the light of day. Question 14. Assertion A. The Government of India Act 1935 abolished the Council of India, which had been created by the Government of India Act 1858. Reason R. The Council of India had become redundant because India's administration was now directly supervised by the Parliament of the United Kingdom. The answer is C. The assertion is correct. The 1935 Act did abolish the Council of India, but the reason given is incorrect. It was not abolished because Parliament was now supervising India directly. It was abolished because the Secretary of State's advisory body had become ineffective and was replaced by a smaller, informal advisory body. Parliament's role in Indian administration did not directly increase because of this change. The abolition was more about administrative rationalization than about parliamentary oversight. Assertion-reason questions love this trap, where the assertion is true, but the reason assigned to it is fabricated or belongs to a different cause entirely. Question 15. Here is a fact scenario. It is August 1947. Two new nations are being born. The Constituent Assembly of India has been functioning since December 1946. Under the Indian Independence Act 1947, what was the formal constitutional status of this Constituent Assembly? A. It remained merely an advisory body until a new constitution was drafted. B. It became a fully sovereign body and also functioned as the Provisional Parliament of India. C. It was dissolved and replaced by a new body formed by fresh elections. D. It continued to function only under the supervision of the British Crown. The answer is B. The Indian Independence Act 1947 gave the Constituent Assembly complete sovereignty. It was no longer operating under the Cabinet Mission Plan or under any British framework. It became sovereign, free to draft any constitution it wished, free to repeal any British law, free to pass ordinary laws. And because India needed a functioning legislature immediately, the Constituent Assembly performed a dual role, as a constitution drafting body and as the provisional parliament until a new parliament was constituted under the new constitution. This dual role ended only when the constitution came into force on the 26th January 1950. Question 16. Which of the following is correctly stated about the Indian Independence Act 1947? A. It fixed 15 August 1947 as the date of independence for both India and Pakistan. B. Mountbatten became the Governor-General of both India and Pakistan. C. The Act terminated the suzerainty of the British Crown over Indian states immediately. D. Both A and C are correct. The answer is D. Let us go through each component. Statement A is correct. Both India and Pakistan became independent on the 15th August 1947. Statement B is the trap. Mountbatten became the Governor-General of India, but Jinnah chose to become the Governor-General of Pakistan himself. Mountbatten did not hold that position for Pakistan. Statement C is also correct. The Indian Independence Act 1947 specifically terminated the suzerainty of the British Crown over the Indian princely states, leaving them legally free to join either dominion or remain independent. That freedom is what made Sardar Patel's integration task both necessary and urgent. Since A and C are both correct, option D is your answer. Question 17. Arrange the following in correct chronological order. 1. Introduction of separate electorates for Muslims. 2. Establishment of the Federal Court of India. 3. Dyarchy introduced in provinces. 4. Governor-General of Bengal becomes Governor-General of India. The answer is A. Walk through it. Governor-General of Bengal becoming Governor-General of India happened under the Charter Act 1833. That is the earliest event in this list. Then came separate electorates for Muslims under the Indian Councils Act 1909. Then Dyarchy in provinces under the Government of India Act 1919. Then the Federal Court established under the Government of India Act 1935, which started functioning in 1937. So the sequence is 4, 1, 3, 2, and option A is your answer. Chronology questions are pure memory tests. Build a mental timeline with the year next to each act, and the questions become automatic. Question 18. Which of the following acts first used the expression British possessions in India? A. Regulating Act 1773. B. Pitt's India Act 1784. C. Charter Act 1833. D. Government of India Act 1858. The answer is B. This is a pure fact question, but it trips up a large number of students. Pitt's India Act 1784 was the first to use the formal phrase British possessions in India. Before this, India was treated as a trading territory of a private company. By using this phrase, the Act acknowledged India's status as territory belonging to Britain, not just a commercial venture. The company may still have been managing it, but the territories were British possessions. This language laid the groundwork for the Crown's eventual complete takeover in 1858. Question 19. Which of the following is not a feature of the Government of India Act 1919? A. Bicameral legislature at the centre. B. Separate electorates extended to Sikhs. C. Introduction of Dyarchy at the centre. D. Establishment of a Central Public Service Commission. The answer is C. Dyarchy at the centre was proposed, but in the Government of India Act 1935, not 1919. The 1919 Act introduced Dyarchy only at the provincial level. At the centre, the 1919 Act brought bicameralism, Council of State as upper house and Legislative Assembly as lower house. It also extended communal representation to Sikhs, Europeans, and Indian Christians, and it did establish a Central Public Service Commission. So options A, B, and D are all correct features of the 1919 Act. Option C is the intruder. Negative MCQs on the 1919 Act almost always try to plant Dyarchy at the centre as a trap. Question 20. The Secretary of State for India was assisted by a council. How many members did this council initially have, and under which Act was it eventually abolished? A. 12 members, abolished by the Indian Independence Act 1947. B. 15 members, abolished by the Government of India Act 1935. C. 15 members, abolished by the Indian Independence Act 1947. D. 12 members, abolished by the Government of India Act 1935, by C. 15 members. The Council of India had 15 members. This body was created by the Government of India Act 1858 to assist the Secretary of State. It was abolished by the Government of India Act 1935, which replaced it with a smaller advisory body. Not the Independence Act, the 1935 Act. This is a two-part fact question. Both the number and the act of abolition must be correct for you to get the mark. Many students remember 15 correctly, but mistakenly attribute the abolition to the Independence Act. The 1935 Act is the right answer. Question 21. Consider the following statements about the Charter Act of 1853. Statement 1. It was the last of the Charter Acts passed for the East India Company. Statement 2. For the first time, it separated the legislative and executive wings of the Governor-General's Council. Statement 3. It fixed a new 20-year term for the East India Company's administration in India. Which of the following is correct? A. Statements 1 and 2 are correct. B. All 3 are correct. C. Only statement 3 is incorrect. D. Statements 1 and 3 are correct. Statement 2 is incorrect. The answer is A. Statements 1 and 2 are both correct. The 1853 Act was indeed the last Charter Act, and it did for the first time separate the legislative and executive functions by adding 6 members to the Governor-General's Council specifically for legislative work, making it a rudimentary legislature. But Statement 3 is the trap. Previous Charter Acts, 1793, 1813, 1833, had fixed 20-year renewals for the company's charter. The 1853 Act was different. It did not fix any time period. It left the company's future open-ended, subject to Parliament's pleasure. That ambiguity lasted only until 1858, when the mutiny gave Parliament the perfect reason to end company rule entirely. Question 22. Satyendra Prasad Sinha became the first Indian to be appointed to the Viceroy's Executive Council. Under which Act did this happen? A. Government of India Act 1858. B. Indian Councils Act 1892. C. Indian Councils Act 1909. D. Government of India Act 1919. The answer is C. The Indian Councils Act 1909, the Morley-Minto reforms, introduced the principle of associating Indians with the executive councils of the Viceroy and the provincial governors. Satyendra Prasad Hinna was appointed as law member of the Viceroy's Executive Council under this Act. This is frequently asked. Do not confuse it with the 1919 reforms, which went much further in Indian participation. The 1909 Act was the first step, one Indian at the executive level, while the 1919 Act brought ministerial responsibility for transferred subjects. Question 23. Which of the following statements about the Indian Independence Act 1947 is incorrect? A. It provided for the partition of British India into 2 independent dominions. B. It empowered the constituent assemblies of both dominions to legislate for their respective territories. C. It declared that from 15 August 1947, no British Act would extend to either dominion. D. It made Mountbatten the common Governor-General of both India and Pakistan. The answer is D. And we come full circle to Mountbatten. He became the Governor-General of India, not of Pakistan. Jinnah took the Governor-General position for Pakistan himself. Options A, B, and C are all accurate statements of the Act. The Act did partition British India, did empower both constituent assemblies, and did terminate the applicability of British parliamentary legislation to the 2 new dominions. Option D is factually wrong and is therefore the answer to this not correct question. Always read negative MCQs twice. The word incorrect in capital letters is there for a reason, and students still choose correct options under exam pressure. Question 24. Legal maxim application. The Latin maxim rex non potest peccare means the king can do no wrong. In the context of India's constitutional history, which act most directly challenged this principle by making the Crown and its servants legally accountable for their actions in India? A. Regulating Act 1773. B. Pitt's India Act 1784. C. Government of India Act 1858. D. Government of India Act 1919. The answer is A. This is a conceptual application question. The Regulating Act 1773 was the first act to prohibit company servants from accepting gifts, bribes, and engaging in private trade, creating legal duties enforceable against individuals working under Crown-affiliated structures. It also established the Supreme Court at Calcutta, which could try company servants. For the first time, the officials of this quasi-Crown entity were made subject to legal accountability. The 1858 Act brought the Crown directly in charge, but accountability mechanisms for Crown servants acting in India were present from 1773. The maxim is being tested as a contrast. The Regulating Act is the correct answer because it was the first step in creating legal restraints on officials in India.